Pag-usapan naman natin yung usufruct. The basic idea of usufruct is property is given to a person, is given the right to use and enjoy the property with the basic obligation of preserving its form and substance. Basically, that's what usufruct is all about. Now, you try to remember at least a few of the distinctions between usufruct and lease. Kung minsan tinatanong yan, you need not remember all of the distinctions. You just remember some of the distinctions. For example, one possible distinction is that usufruct is always a real right. In the case of lease, it's not always a real right. It becomes a real right only if the period is more than 1 year or if it is registered. A usufruct can only be created by a person who owns the property. Siya lang ang pwede mag-constitute ng usufruct. Yung lease pwede, it be created by somebody who is not actually the owner of the property. For example, the lessee may actually sublease the property. In the matter of its creation, there are various ways of creating a usufruct. It may be created by the law itself. It may be created by the will of a testator. Okay? In the case of a lease, generally, the only possible source of lease is the contract between the parties. Except, of course, in the case of the implied new lease or in the case of the forced lease under Article 448. If the value of the land is considerably more than the value of the building, the landowner cannot compel or ask the builder to buy. They may just enter into what is sometimes referred to as a forced lease. Yung mga ganyan. Tandaan lang natin yan. You remember the rights of a usufructuary. So, if you are the usufructuary, what will be your rights? Basically, you can use the property. You're entitled to all of the fruits, whether natural, industrial, or civil fruits. Supposing there are hidden treasure there. Insofar as hidden treasure is concerned, the usufructuary, the law says, is considered a stranger. In other words, if somebody finds the hidden treasure, then the usufructuary does not get any share of it. If it is the usufructuary himself who finds the hidden treasure, then he may be entitled to 1/2 of the hidden treasure and the other half will go to the naked owner of the property. You remember the provisions of the law regarding growing or pending fruits. Those fruits which are growing or pending at the commencement of the usufruct will belong to the usufructuary. Those growing or pending fruits at the time of the end or termination of the usufruct will of course belong to the naked owner. With respect to the fruits pending at the time of the start of the usufruct, sabi natin, they would belong to the usufructuary. Does he have to refund to the naked owner the expenses incurred? So far, there is no need to refund the expenses. But when it comes to the fruits pending at the time of termination of the usufruct, while the law says that they will belong to the naked owner has to reimburse the usufructuary the expenses incurred by the latter for cultivation, seeds, and other similar expenses. If the property under usufruct is tenantable, pwedeng i-lease or i-rent out to tenants, it is the usufructuary, not the naked owner, who has the right to determine who will be the tenant of the property. If there are any accessions, halimbawa, the property under usufruct happens to be a parcel of land, it's located along the banks of a river, and in the course of time, the area increased because of alluvion, the usufructuary has the right to make use of the additional area. That's part of his right under Article 571. The usufructuary may decide to personally use the thing, personally enjoy it, or he may allow another person to enjoy the thing under usufruct. But remember that all contracts entered into by the usufructuary with third persons are coterminous with the usufruct, with the exception of lease of rural lands, which shall be deemed to continue up to the end of the agricultural year. The obvious purpose there is to allow the lessee who may be cultivating the land to continue with the production and gathering. Usufruct imposes upon the usufructuary the obligation of preserving the form and substance of the thing. But the law allows the grant of a usufruct over the entire patrimony of a person. And when that happens, chances are, in that patrimony, there will be some properties which by their very nature will deteriorate or will be impaired due to ordinary wear and tear. Supposing that what has been given by way of usufruct is property which gradually deteriorate through ordinary use, ordinary wear and tear. Halimbawa, a car. Siyempre, kotse. If the usufruct is for 5 years, after 5 years, iba na yung kotse yan. Ordinary use of the car will result in ordinary wear and tear. Can the usufructuary use the property? The answer is yes. Pwede pa rin. What will be his obligation? He is simply obligated to return the thing in the condition in which it may be at the time of termination of the usufruct. Of course, if the thing suffered damage or injury due to his fraud or negligence, he is obligated to indemnify. Pero kung ordinary wear and tear lang, no obligation. Okay? He simply has to return the thing in the condition in which it may be found at the termination of the usufruct. Can there be a usufruct on consumable things? Those which cannot be used in a manner appropriate to their nature without their being consumed or used up. Can there be a usufruct on money? Can there be a usufruct on rice, for example? The answer is yes. These are what are sometimes called abnormal usufructs on consumables, sometimes called quasi-usufructs. But I think the better view is, well, as pointed out by some commentators, if the object of a usufruct is consumable, in effect, what you have is a simple loan. Okay? So what will be the obligation of the usufructuary? Siyempre, he uses, he consumes, then he simply has the right to return or pay their appraised value at the time of termination of the usufruct, if they were appraised. Now, if they were not appraised, he will have the obligation of returning the same quantity and quality or pay their current value. That's one advantage of having an appraisal. At least, you only have to return the appraised value if they were appraised. With respect to usufructs on fruit-bearing trees, remember, the usufructuary cannot cut down the trees, but he is allowed to use the trees which have been uprooted by accident, yung mga dead trunks. He can use them, but if he does, he has the obligation to replace them with new plants. If there is something extraordinary which happens, and the trees have been uprooted or disappeared in such extraordinary number that it would be impossible or too burdensome to replace them, the usufructuary may simply demand from the naked owner to clear the land so that he can continue using the land, or if he wants, he can use them, but if he does, he will have the obligation to replace them with new trees, pursuant to Article 575. Usufruct over woodland. The usufructuary is allowed to make such ordinary felling and cutting as the owner was in the habit of doing or in accordance with the customs of the place. You remember in this connection that coconut land is not considered woodland. So, hindi pwede magputol ng puno ng nyog ang usufructuary. Supposing the usufructuary introduces useful improvements or improvements for mere pleasure, ornamental improvements on the property under usufruct. Can he do it? Yes, as long as he does not alter the form and substance of the thing under usufruct. Can he demand reimbursement for the expenses he incurred? The answer is no. He cannot claim reimbursement for the expenses he incurred for useful and ornamental expenses or improvements. But he can set off the value of these improvements against any possible liability for damages which he may have incurred. What are the obligations of the usufructuary? At the start of the usufruct, there are two basic obligations of the usufructuary. Number one, he must submit an inventory of the things under usufruct. And number two, he must also give a sufficient security. What will be the security for? That is to guarantee his compliance with his obligations as a usufructuary. When is an inventory not required? When no one will be injured, provided, of course, the naked owner consents to the non-submission of the inventory. In case the naked owner waives the requirement for an inventory, or if there is such a provision in a will, where the usufruct was created by will, or in the contract creating the usufruct. What about the security? When is a security not required? Again, when no one will be injured, provided the naked owner consents. Number 2, if there is waiver on the part of the naked owner. Number 3, if the usufructuary happens to be the donor of the thing, sa kanya nang galing, binigyan niya, but he reserves the usufruct of the property, he is not required to furnish a security. If there is a caution horatoria, the promise under oath, the usufructuary is also not required to furnish a security. What will be the legal consequence if there is a failure to provide the security? We have the provisions of Article 586 of the Civil Code. In that case, the naked owner may demand that the immovables be placed under administration, that the movables be sold, that the public bonds, instruments of credit be converted into registered securities or certificates, and that the proceeds of the sale of the movables be invested in safe securities. The usufructuary, of course, will be entitled to the interest on these sales of the movables and the other proceeds of the property placed under administration. What is the caution horatoria? Sometimes it may happen that the usufructuary is given the usufruct of certain properties, house, for example, furniture, equipment, and tools. Pero walang-wala. He does not have money to get the necessary security. In that case, he may petition the court to allow him to make use of the house so that he and his family can live there, that he be allowed to use the furniture, that the tools and implements of a trade be given to him so he can use it, so that he can earn money. That may be granted by the court upon the promise of the usufructuary under oath. Kaya ang tawag diyan, caution horatoria. That he needs the property, he will take care of it as required by law. A usufructuary, of course, is obliged to take care of the thing with the diligence of a good father of a family. Supposing he fails in that obligation, he abuses the thing, he misuses the things under usufruct. Will that cause the termination of the usufruct? The answer is no. What is the remedy of the owner in that case? The owner may simply ask that administration be given to him, pursuant to the provisions of Article 610 of the Civil Code. If the usufruct is constituted on a herd of livestock, the law says he is obligated to replace with the young thereof those which are lost each year due to natural causes or due to the rapacity of beasts of prey. Yung mga nawawala dahil sa mga mandarambong beasts of prey, mga hayop na mawabagsik. Supposing that the usufruct is constituted on sterile animals, yung mga hayop na baog, hindi pwedeng manganak. What's the obligation of the usufructuary? It will be considered as if the usufruct was constituted on fungibles. In other words, the usufructuary simply has the obligation to pay their appraised value if they are appraised, or if not, he has the obligation to replace them with the same quantity and quality, or pay their current value at the time of the termination of the usufruct. A good example of a sterile animal would be a mule, M-U-L-E. A mule is a sterile animal. And you produce a mule by crossbreeding a male donkey with a female horse. Pag nag-crossbreed ka ng male donkey at female horse, the offspring will be a mule. Sterile yun. Alright. Who is responsible for repairs? You distinguish between ordinary and extraordinary repairs. Ordinary repairs are the responsibility of the usufructuary. When is a repair considered an ordinary repair? If it is due to wear and tear and it is indispensable for the preservation of the thing. So, two requisites must be due to wear and tear and it must be indispensable for the preservation of the thing. That will be considered an ordinary repair. the usufructuary is obliged to make the ordinary repair. All other repairs are considered extraordinary. Halimbawa, due to wear and tear, but not indispensable for the preservation of the thing, that's considered extraordinary. Extraordinary repairs shall be, according to the law, at the expense of the naked owner. But the naked owner, please take note, is not obliged to make the extraordinary repairs. Supposing the naked owner makes the extraordinary repairs, he spends for the extraordinary repairs. What right would he have? Under the law, he would have the right to demand from the usufructuary legal interest on the amount he spent for the extraordinary repairs for the duration of the usufruct. Supposing that the repair is extraordinary, indispensable for preservation but not caused by ordinary wear and tear. Halimbawa, the property under usufruct is a house. May malakas na bagyo, nilipad ang bubungan. That's not due to ordinary wear and tear. But that repair is indispensable for the preservation of the property. And let's further assume that the naked owner does not make that extraordinary repair. In that case, since it is indispensable for the preservation of the thing, the usufructuary may make that extraordinary repair. What would be his rights? If the usufructuary, under those circumstances, makes the extraordinary repair, he may demand from the naked owner at the termination of the usufruct the increase in value which the thing may have acquired as a consequence of the repair. Annual charges and taxes, which are considered lien on the fruits, charged to the usufructuary. Real property tax on the land under usufruct, that should be paid by the naked owner, not by the usufructuary. If the usufruct is constituted on the whole patrimony of a person and the naked owner happens to have unpaid debts, is there an obligation on the part of the usufructuary to pay the debts? If there is no order from the naked owner to pay the debts, there is no obligation on the part of the usufructuary to pay those debts, except if the usufruct was constituted in fraud of creditors. If there is an order from the naked owner for the usufructuary to pay the naked owner's debts, it is understood that he is obligated to pay the debts existing at the time the usufruct was constituted. Only pre-existing debts must be paid, applying the provisions of Articles 758 and 759 of the Civil Code. How is usufruct extinguished? You take note of the provisions of Article 603 of the Civil Code. The death of the usufructuary generally terminates the usufruct. What about the death of the naked owner? It does not terminate the usufruct. Merger would also result in termination of the usufruct. Meaning to say, if there is merger of both the usufruct and the ownership of the same property in the same person, then the usufruct is necessarily terminated. Total loss of the thing, that also results in the termination of the usufruct. Termination of the right of the person constituting the usufruct, that also terminates the usufruct. If I gave you a usufruct over a parcel of land, and during the existence of the usufruct, my rights are declared by final judgment of a court to be null and void, I'm not really the owner, then that's an example of a situation where the usufruct would be terminated by the termination of the rights of the person constituting the usufruct. Renunciation on the part of the usufructuary, that would also terminate the usufruct. Does a renunciation require the consent of the naked owner? The better view is that it does not. If the loss is not total but partial, of course, needless to state, sabi nga, the usufruct continues on the part of the thing which has not been lost. In the case of multiple usufructs, it is only upon the death of the last usufructuary that the usufruct is terminated. Supposing that the usufruct is granted for the number of years that would elapse before a person would reach a certain age. Let's say I gave you a usufruct today until X reaches the age of 40. And X is, let's say, only 30 years old today. So, the usufruct is supposed to last for 10 years. Okay? Until he reaches the age of 40, is only 30. Supposing X dies after 5 years, will the usufruct terminate? The answer is no. It continues until the year when he is supposed to reach 40, after 10 years. unless, of course, the usufruct was granted only in consideration of the existence of X, in which case it would terminate upon the death of X. You take note of the provisions of Article 607. Two situations contemplated here. First situation, usufruct is constituted on both the land and the building. The building is destroyed. What's the consequence? The usufruct over the land continues. Usufructuary has the right to continue using the land, and he has the right to make use of the materials. If the naked owner wants to rebuild, his decision is subject to the concurrence, is subject to the consent of the usufructuary, because his usufruct is over both land and the building. If the usufruct is constituted on the building only, not expressly covering the land, and the building is destroyed, of course, the usufruct on the building ends, but the usufructuary can still make use of the materials. The usufructuary in that situation is also entitled to the continuous use of the land, because although the land was not expressly included in the usufruct was given only over the building. Of course, a building cannot be floating on thin air. So when he was granted usufruct of the building, necessarily kasama din yun yung pinagkakatayuan nun. It necessarily included his right to make use of the land on which the building stands. If the naked owner rebuilds, he has the obligation to pay the usufructuary interest not only on the value of the materials, but also on the value of the land. Bakit may interest pati sa value of the land? Because, sabi nga natin, even if the usufruct expressly covered only the building, it necessarily included the use of the land, because a building cannot float. If the property under usufruct has been expropriated, what will be the legal consequence? The naked owner has the obligation to either replace it with another property of the same kind and value, or, depending upon the naked owner, he can simply pay the usufructuary interest on the indemnity paid to him. This was precisely the rule applied by the Supreme Court in the case of Locsin versus Valenzuela, where the property under usufruct was taken under PD 27, given to the tenant.